Dear friends, today our topic is whether the evidence of a witness to whom the oath is not administered, whether it is admissible in evidence or not. So this is the main point. Please remember. So here evidence is given but not under oath. Then whether it is admissible or not. This is actually it was solved previously because it relates to the Oaths Act. But anyway, it's a good topic. Let us discuss the same. Right. Please, I hope I need not reiterate that whenever any witness enters the box, then he has to take the oath and his evidence will be recorded only on oath. That is after administering the oath. Normally, the oath will be previously, they used to take it on Bhagavad Gita or Quran or Bible like that. Of course, that's an old practice, and now just simply saying that I so-and-so will speak the truth, whole truth, nothing but truth. That itself is simply sufficient. So this is as per the Oaths Act. Previously it was called as the Oaths Act 1873. Of course, the modified act is the Oaths Act 1969. So previously there were 13 sections in 1873 Act, but in the present Act there are only 9 sections. Right. Here, please remember section 4. Let us talk about the present Oaths Act. Section 4 is more important. Section 4, clause 3 says, when the witness is under 12 years of age and when the court is of opinion that the witness does understand the speaking of truth but does not understand the nature of the oath or the affirmation. Therefore, the foregoing provisions of next sections, that is section 5, 6, they will not apply to such witness. That means even though her evidence, the witness evidence is recorded, it goes only to the credibility but not the competency, because she is not competent to give evidence because she does not understand the term oath. Here we have to know about 2 terms, oath and affirmation. Simply to say, oath means swearing in the name of the God or in your conscience or in the name of some other person, in the name of some God whom you like. But affirmation means in the conscience. That means a secular, since ours is a secular society, the other word is affirmation. So you need not swear in the name of God. You can say that I solemnly affirm on my conscience. It will be sufficient. Either oath or affirmation, both words convey the same meaning. So here, right, please remember, the main condition is if the witness is below 12 years. And second point is if the witness understands that she has to speak the truth, speak the evidence, she has given evidence, but the witness does not understand what is an oath and what is an information. Even then, her evidence, the evidence of the witness can be recorded without taking the oath. In such cases, whether it is admissible or not. Yes, 100% admissible. So you cannot go against the credibility of the witnesses, even though she is not competent to give the evidence. So now, coming to the competency of the evidence, please remember section 118 of the Evidence Act. What does 118 Evidence Act say? Section 118 Evidence Act says that anybody is competent to give evidence unless in the opinion of the court that witness is not able to understand the, I will tell you the clear section, it will be easy. Right. All persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them. So, if they are not able to understand the questions or from giving rational answers to these questions by the reason of tender age. Second, extreme old age. When once you become extreme old, normally you may not be able to remember. And third one is any disease of the body or of mind, or any other cause. Under these circumstances, they may not be competent to give evidence, right? So here section 4 clearly says if the witness is below 12 years, yes, her evidence or his evidence can be recorded, because even without affirming or without taking the oath. So here, therefore, he can be called as a competent witness, right? Normally, so it happened in the case of so many persons, including Kiran Bedi also. And in first instance, she refused to take oath in the court. Then only we came to about the so-called Oaths Act 1873. The court insisted to take the oath. Please remember, if you don't agree to take the oath, so suggested by a public servant. So if you fail to take the oath, if you refuse to take the oath, please remember, it is an offence under section 178 of the Indian Penal Code, which may give 6 months punishment or 2,000 rupees fine or things like that. Of course, it's a non-cognizable offence, so please remember, you can be dealt with if you don't oblige to the oath. But here the point is, when the witness is below 12 years. So here section 7 says, no omission to take the oath shall invalidate the proceedings or render any evidence inadmissible because of that tender age. So please remember, what is the main object? The main object of the oath is to render persons who give false evidence to take them to perjury. Perjury may be known. Perjury means giving false evidence. It will be dealt with 211 for giving all these things, 211 of the Indian Penal Code. So if you go, it is only actually a sentimental aspect, and the procedure is also only to inculcate a sense of fear among the witness that when once you enter the bone, you have to speak truth, only truth and nothing but truth. Otherwise, you will, of course, I have seen 70 or 80% of the witnesses who are particularly from rural area, definitely they will abide or they will stick to their version. Whatever they say in the before the police during investigation, normally they repeat the same. Of course, there are so many other witnesses also, so many stock witnesses, so many different types of witnesses, they will definitely go against the version. There are these two types of persons we are finding throughout our career, right? Please remember, there is supporting evidence. Now, the evidence, please remember, even though the oath is not registered, administered, and the evidence is taken, it does not become admissible. It can be admissible. This is this is a decision. We can take it as stare decisis. Privy Council in Muhammad Sugal Isa ESA versus the King 1946. It held that, so previous section 17, present section 7. So it is quite unqualified, and there is nothing to suggest that it is to apply only where the omission to administer the oath occurs per incurium. That means even though the oath is not administered, definitely the evidence can be taken into account. And there is another decided case like Rameshwar versus the state of Rajasthan 1951. So what happened here? Here the Rameshwar case, in Rameshwar case, he is the accused, actually he is the appellant. What happened is, this happened in the year 1951. So the accused, actually he committed rape on the victim who is aged about 8 years in the absence of her parents. Actually her parents, they went to the field to eke out their livelihood, to work as a laborer, and by the time they committed the offense around 12:30 or 1 p.m. So when the mother came back from the field around 4 p.m., then this girl weeping told the incident, then they informed the elders, and ultimately there is some delay in reporting the matter. Right, okay, the police arrested the accused, the charge sheet was taken on file, and so when the trial is commenced and when her deposition has to be taken, the judge, according to section 118 of the Indian Evidence Act, he put some questions to her to test her rationality. That means whether she can understand the questions, whether she is able to give rational answers or not, whether Then he came to the conclusion that she is able to understand that she has to give evidence and she can give evidence, but she doesn't know what is oath and what is affirmation, and therefore he did not administer the oath to her but took her evidence. Now the defense plea is that since the evidence is not on oath, it is totally to be rejected. Of course, there are some contradictions in the version of the mother and this girl. Of course, when put together, so when the court corroborated all the three evidences, that is her brother, he was also a young boy, just aged 9 years. So her mother and this girl, when all of them were put together, the fact came to light that she went, the accused came to her house, took her out on the plea of something, and he attempted to commit rape on her. So this fact was proved and he was given conviction. Of course, at that time 1 year and 200 rupees fine. So the court agreed that even though no oath was taken, her evidence is admissible, right? Same is in another case also. The credibility was taken in section, of course, in the case of State of Rajasthan versus Vijayaratnam, 1967. Here also the girl is aged, her evidence also, she does also understand, she can understand the questions, but she doesn't know the consequences of this oath or affirmation. So her statement was recorded without administering the oath on her, and basing on her evidence coupled with the evidence of some other witnesses, the accused was convicted. Because according to section 8 of the Evidence Act, facts forming of the same transaction, of course here the mother, in the previous case the mother, brother, all of them, they told the fact is the same, that the accused entered the house, took her out, and he attempted to commit rape on her. Here the accused committed rape on her. So these are the instances where, please remember, the evidence will become admissible even though not taken on oath. This is a good judgment, previous judgment. Of course, nowadays you may not be able to give to come to that aspect, but I came to know that during I think maybe 1969 or so, one witness, he has taken the oath in the name of Sayyid Pir Dada. That means he is in whom he is a God in whom he has got trust. But Supreme Court directed that as per the Rule 44 of the Oaths Act, the Oaths Act rules, so he has to take oath either in the name of God or in the name of his conscience. That's all. Not in the name of Pir Baba, Meher Baba or something. So once again, the matter was remanded to the lower court that the oath should be administered properly, and it was taken. Of course, the number of judgments are very less. Anyway, please remember, even so, the section 4 is more important in this Oaths Act. So the very purpose of Oaths Act is to render it subject to the perjury. So if you say anything false, you can be taken to task. Of course, we are saying nowadays even the so-called 164 statements are becoming an uproar. All of them are turning hostile. Of course, court is not in a position to take them to task for perjury because a lot of other material also should be available. But anyway, these are good judgments. So of course, outdated, old one, but still useful because you will be learning about the Oaths Act, Section 118 of the Evidence Act, Section 178 of the IPC, and also a little bit of Section 8 of the Evidence Act. Thank you.